Welcome to the subcommittee of the Environment Select Committee. I'm chairing the session. I'm Hamish Campbell. We've allocated you 10 minutes to hear your oral submission. So perhaps if you could leave some time at the end for questions, would be most appreciated.
Tēnā koe. Kia ora koutou, e te Committee Whiriwhiri. Nōku tua Māori e ki te kōrero ki a koutou I tēnei rangi. Thank you very much, everyone, for this invite to come and speak to this committee on behalf of the Asian Legal Network on the Fast Track bill. My name's Darren, and I'll be speaking. I'll try and keep my submission short so we can have some questions at the end. Just a little bit about the Asian Legal Network. We are a research and advocacy group that advocates for the interests of Asian peoples using things like the law and submission processes, and we do so under a Te Tiriti framework. We really support Te Tiriti o Waitangi. I think that's a really important part of our belonging here in Aotearoa and for the interests of Asian peoples. In terms of this bill, we are submitting against it, and we have three main reasons which we've outlined in our submission. The first one is we think that this undermines the obligations on the Crown and breaches Te Tiriti o Waitangi. Secondly, we submit that there are some real concerns around democracy, public participation, and transparency of government decision-making. And thirdly, we also think that this bill is actually is actually harmful to the interests of Asian peoples living in Aotearoa. So just firstly turning to the first submission, we think that the Kāwanatanga is set up because of Te Tiriti. It has these obligations. These obligations are set up quite clearly with things like the Waitangi Tribunal reports have been meant to be honoured, and they clearly haven't been. We think that what this bill does is that it shifts a significant amount of power into the joint ministers. We think that the amount of input from mana whenua is extremely limited. Just listening to other submissions, we clearly see that from mana whenua themselves, from different iwi groups, this is a clear breach of a lot of Te Tiriti obligations and the articles of Te Tiriti themselves: honourable governance, tino rangatiratanga. And even if you take a principles framework, things like partnership, meaningful participation, protection, even the fact that there's a differentiation between iwi who have settled and those who haven't, we think that this will cause more problems down the line. And we think that this is a problem for two reasons and why it's important for the Kāwanatanga. Firstly, we think that this further undermines the legitimacy of the Crown and how it operates. And that is not a good thing. We think the Crown should be honourable in how it operates, and the lack of meaningful co-governance, co-design, and decision-making is a big problem to that. Secondly, we also think that it's important for race relations and social cohesion. We note that every time it's often tangata whenua who have their rights undermined, and that actually ruptures the fabric, the social fabric of Aotearoa. This isn't beneficial for anyone, and it's not beneficial for Asian communities, but we just think that for these reasons, it's really important that Te Tiriti should be upheld. And we think that the bill doesn't do that enough. There's no mention of Te Tiriti. There are some mentions of treaty settlements, but it's simply not enough, in our opinion, to uphold Te Tiriti o Waitangi in any meaningful way. We also think that democracy, transparency, and just turning to the second part of our submission, is really, really important here. Firstly, it's important for trust and the reputation of Aotearoa on the international stage. We should be jealously protecting our reputation, and we sit quite highly on the anti-corruption perception indices. With these sorts of the problem with obviously Aotearoa and its setup with the Westminster system is that there's a huge crossover between the legislative branch and the executive branch, and when you put power just in the ministers and not giving that power to an expert body, this creates more issues of perceptions of corruption. We have just seen recently, I think Forrest and Bird recently just submitted on the issue of Minister Jones and having some undeclared dinners. We saw that even just the mention of this bill increased the stock prices of certain mining companies. And what this does is that it's just a perception issue, and it actually undermines the role of ministers. If a project went badly, this reflects badly on the government of the day, on the minister. Whereas if you devolve that power, you can create that separation like we saw with the COVID fast-tracking legislation. And that buffer is beneficial for the government itself and its reputation and trust. We think in this particular context, with the lack of trust in governments and declining globally, we think that this bill will undermine that trust further. Again, we think that things like decision-making and independence is extremely important. We get better decision-making from that. And also, we just like to make a couple of short notes on the fact that if the purpose of the bill itself is to create projects with significant regional and national benefits, then the people living in those regions and nationally need to be able to be notified and have the ability to submit on that. While we looked at, and we've mentioned this in paragraphs 20 and 21 of our submission, multiple places where notification periods are taken out and minimized. This means that the decision makers will not have the fullest impact of who actually benefits. In fact, it will be the person making the application or the company making the application, and it won't actually be focused particularly much on the benefits of ordinary New Zealanders. And lastly, we just wanted to also highlight, just in terms of democracy transparency, a question of comity. Even the Court of Appeal recently released its judgment, Skerritt White, earlier this week, highlighting again the importance of comity, different context, but comity still exists. That is between the legislative and judicial branches. We think that, that requires Parliament itself to have restraint. And because that there are already certain projects that have been, taken up all the way to the Supreme Court and have been turned down, this sort of open zombie projects that have been declined now being able to be continued, we think this actually breaches comity, and the committee should take a serious look at that. Very importantly, of course, we want to represent the interests of Asian peoples. We understand that Asian peoples are a hugely diverse group, but there are some common themes here. The first is when there is lack of social cohesion, this is not beneficial for Asian peoples and Asian communities. We also think that many Asian peoples are not well represented in a lot of government and policy and decision making. Generally, we meet all the new Asian MPs who've joined, but broadly speaking, they're already not represented. When you then reduce general public consultation even more, Asian peoples get disproportionately impacted by that. Their voices are minimized, and we're really concerned about that front. We also know that many Asian peoples have often moved to Aotearoa with the aspirations of living in a place with a healthy environment and have recognized the excesses of colonial and corporate extraction that have caused environmental impacts in different parts of Asia. And we're seeing that this bill mirrors that very, very closely. It allows a lot of power concentrated in the hands of government and corporates, not in the average people. And we think that this is a really detrimental thing for Asian communities living here. So those are our main submissions that we'd like the committee to really consider in not supporting this bill any further. Kia ora.
So thank you, Darren, for your submission. Like I see, Scott Willis has his hand up. Scott.
Kia ora, Darren, thank you, and thank you for acknowledging Te Tiriti. And I want to touch on your mention of trust. What impact will a decline in trust have for the function of government, do you think, that you've argued about in this bill?
We think functioning of trust is extremely, so functioning of government's based on trust, the consent to govern, who actually goes to these services. Are people actually turning to government to fix their own problems, or are they trying to solve it themselves because they're not trusting the government? We think the most extreme version of this was misinformation being able to be built up, and that led to protests on your lawn outside Parliament. And that's unfortunately the environment we live in. So trust is extremely crucial for buying in to government, for following the services, paying taxes, and just basic forms of government.
Excellent. Thank you for that. One of our earlier submitters today actually in their submission had written, while anyone exercising functions and powers and duties under this bill will have to act in a manner that is consistent with the obligations arising under existing treaty settlements and customary rights, which probably is in a little bit of contrast about what you're presenting. What's your view on that?
If I could just clarify, I think that the operation under the treaty settlements and customary rights is still a very, very narrow and limited form of what the Kāwanatanga, the government, signed up to in Te Tiriti. It's a great way of being able to minimize these obligations and force a piece of legislation through Parliament like this. And that, I think, is our concern, is that it's not following what was originally signed in Te Tiriti, and it's a very, very, very limited form of protection and rights that was agreed to.
Yeah, we might have slightly different takes on what it means, but appreciate your submission. If there's no further questions, We'll move now to Irrigation New Zealand, and I do believe we have Vanessa with us now.
Kia ora koutou.
Thank you very much.